Assalamualaikum warahmatullahi wabarakatuh. Hello everyone. Now today we'll go for directors of the company. Okay, I will give you some brief explanation on directors of the company, and we are doing this according to the Companies Act 2016, right? So let's go to the next slide. Who is a director? Who is a director? A director is the one who manages the business and affairs of a company. Okay. Who says this? Section 211 of the Companies Act. Section 211 of the Companies Act, subsection 1, mentioned that, provide that the business and affairs of a company shall be managed by or under the direction of the board. Board of what? Board of directors. Okay, remember section 211. This section gives the powers to the directors to manage the business and affair of a company. Okay, the board, subsection 2. The board has all the powers necessary for managing and for directing and supervising the management of the business and affairs of the company. Right? So basically, there are two parts. Yeah, we are going to the first part. The first part says that the board has powers. Right? The law gives the board powers to manage. Right? To do whatever necessary for the betterment of the company, to do something good for the company, so that the company can run its business without any hiccup. Right? This is the first part. Let's go to the second part. You see, subject to any modification, exception, or limitation contained in this act or in the constitution of the company. So, the board, directors, they do have power. All right, it given to them the powers, right? But with limitation, right? With limitation, because in the other sections and Companies Act, right, the law limits the power of directors. For example, before the directors want to issue more ordinary share, they need the approval from the members. That is limitation, right? Or in the constitution of the company. If the company has a constitution, the company decided to adopt constitution when the company first being incorporated. Okay, so and the constitution limit the power of the directors. So this is limitation by constitution, right? General rule, the directors, the board of directors, they have power, but later on this power is being limited through this act, Companies Act, or the constitution of the company. Right. Directors basically act as an agent for the company. All right, the directors are the agent of the company, so they have fiduciary duties. All right, the agency relationship exists in which they have to act without any negligence. All right, they have to act without any intention to gain benefit for their own self. Right. I would like to refer to Great Eastern, RY, and Turner case. All right, directors are the mere trustee. In this case, it's stated that directors are the mere trustee or agent of the company. Okay, trustees of the company's money and property. So they are trustees. They are not the owner. Right, agents in the transaction which they entered into on behalf of the company. So when the director entered any transaction, any contract, basically the directors not acting on their self, okay, on their behalf. They are acting on behalf of the company. When they act on the behalf of the company, there are many rules that they have to follow. They cannot simply do something because they want to do it. Okay, we will go further on duties and powers of directors later on in the next lecture. Right. So let us go to the next slides now. I would like to share with you the type of directors in Malaysia. I got it from our website. All right. What are the types of directors in Malaysia? We have 1, 2, 3, 4, 5, 6. Right. So we have executive directors. You used to hear this, isn't it? Executive directors, non-executive directors, nominee director, de facto director, shadow director, alternate or substitute director. Right? All the names of directors. Basically, they are director of a company, right? Executive director. Who is this executive director? Basically, he is the person who works for the company on a full-time basis, and he manages the day-to-day running of the company. This is executive director. Non-executive director, what's the difference? Right, basically non-executive directors does not work for the company in a full-time capacity. Okay, they do not participate in managing the company day-to-day basis. They don't do this. Daily business they don't do. Right, their job is not to run the company, but they keep a close eye on the managers and executive directors. So this is the duty of a non-executive director. You see the difference? One is running the day-to-day business. Another one is taking care of the one who actually running the day-to-day business. Okay. Let's go to nominee director. Basically, nominee director is a person appointed by virtue of his position and an employee of a company, or who was appointed by or as a representative of a shareholder, right? No employer or debenture holder. Remember I said proxy or nominee earlier lecture. Do you remember proxy or nominee? When we talk about members, I have a nominee, I paid the shares, but then I put the nominee's name in the name of the members. Do you remember who is the members? That's the nominee's name, so he is the member, not me. Do you remember that? Okay, go to the LA lecture if you don't remember this, right? Listen to the lecture again, right? Nominee director. De facto director. Basically, a person who acts in the position of director with or without lawful authority. This is de facto director. On fact, he's the director. Okay, what do you mean with or without lawful authority? What does it mean? Okay, it means like what it means is this. Okay, you know, sometimes we need there's a process to register a person as a director. Okay, the process of registering a person as a director. So, for example, a person act as a director, right? How do I say? Let's say Mr. Jamil. Company XYZ appointed Mr. Jamil as a director. Upon getting the letter, he started to work as a director. However, his appointment has defect. This is what we call as a defective appointment, right? So, even though the appointment is defect, Mr. Jamil now is a de facto director. Okay. Shadow director. Before we go for shadow director, I would like to share with you that de facto, basically it means in fact, or whether by rights or not. So that's what it means by de facto. So I repeat, yeah, a de facto director basically is a person who actually being appointed by the company, not officially. Okay, who is the company has not officially appointed as a director. However, this person, they still act as if they were in the position of a director. Okay, so if they go to court, you know, court may still recognize them as a de facto director if their action indicate this to be the case. Okay, if they go to court, the court will see and say, oh, okay, they're being appointed but not officially, so they are de facto director. I hope you understand what does it mean by de facto director. So now we go to shadow director. Who is this shadow director? Okay, shadow director is a person whose instruction or direction, okay, listened to by the majority of the directors of a corporation. Right, although this person may not been appointed, has not been appointed as a director, he still control the action of the boards of director like a shadow. Right, so the majority of the directors act on his direction or instruction as a matter of practice. He might not be a director in the company, he may not be, okay, but the board of directors listen to him. This is a shadow director. You have to imagine shadow. Alright, it's not there. Oh, it's scary, no? When you say shadow, I don't know why I feel that it is scary. Wow, the person is not there, but you listen to him. The board of directors acted upon his instruction. Right. Enough with this shadow. We go to alternate or substitute director. An alternate or substitute director is a person nominated by another director to attend meeting or perform duties on his behalf. Right? But alternate or substitute director can only be appointed if it is permitted by the company's constitution. Okay, if the company's constitution allow the appointment of alternate or substitute director, then only this kind of director can be appointed. So this is the type of directors in Malaysia. Next, qualifications of directors. Does a director need degree, law degree, or to have accounting degree? Whoever can be director even though without degree or without SPM or without UPSR. So now we have to look at the qualification. What does it mean by qualification? So we'll look at the next question. Who may be a director? Right. I put section first because you are learning law, my dear. Section 196 subsection 2. A person who reaches the age of majority. Who may be a director? A person reaches the age of majority. How old is that? Remember, 18 years old. The earlier slides, I put 18 so big. Remember that? Right, next. Section 196 subsection 2. A natural person. A company cannot be the director of a company, another company. Section 198 subsection 3. Okay? A person who is not bankrupt. Okay? Alright, if a person is a bankrupt, but he got approval from court, this is allowed under section 198 subsection 1. Okay? Section 208, a person who is not unsound mind, which means he is a not crazy people, alright? A sound mind person. Right? Sound mind person. Unsound mind cannot be a director. That's why you see law sometimes tricky. Not unsound mind. It really means that this person not unsound mind. It doesn't say sound mind. It says not unsound mind. So sound mind person can be a director. Okay. Now, remember qualifying shares earlier lecture? Okay. Who may be a director? A director whom a requirement or qualification stated that he needs to acquire qualifying shares. He needs to acquire qualifying shares. So a person who has the minimum share to become director if required by constitution of a company. So the company make a requirement in the constitution stating that if a person want to be the director of the company, he must acquire 5% of the company shares, for example. Okay, so this is qualifying shares. All right. For example, a person shall have, I put example here, look at the arrow. A person shall have at least 10% of the shares in the company to become the director of the company. All right. This is qualifying shares. Okay, this person can be a director. So we go to the next slide. So let us see the minimum number of directors in a company. This is provided by section 196 of section 1. For private company, the minimum number of directors is 1. Public company, minimum is 2. Okay. The minimum directors must have principal place of residence in Malaysia. Principal place of residence doesn't mean that the person must be the citizen of Malaysia. Okay. Okay, it does not mean that the director must have citizenship of Malaysia as long as the director primary place of residence is in Malaysia. This is provided by the court in the case of Fong Poh Yok and the Central Construction Company Malaysia Sdn Bhd. appointment of directors. How to appoint directors? Okay. The first director of the company, since it was incorporated, okay, the directors are the person who actually being named in the document of incorporation of company, isn't it? So the person who were the promoters that incorporates the company under section 202 subsection 1. Okay. For the subsequent director, the director must be appointed by ordinary resolution in meeting, okay, as in pursuant to section 202 subsection 2, right? Right. This is done by the board of directors if the constitution allows, as pursuant to section 202 subsection 3. This is for subsequent directors. So appointment of directors, the first one when the company was incorporated, and after that when the company sees that they need more directors. Okay, the board of the BOD feels that, okay, we need more directors, or the shareholder decided that they want to have one more directors, for example. Okay, for example. All right. So the subsequent must follow subsequent appointment must follow section 202 subsection 2, where they need ordinary resolution in a meeting. Okay. Removal of directors. Okay. How to remove directors? We have to refer to section 206 of Companies Act. Okay. The directors could be removed by ordinary resolution passed in the meeting of members. Alright, passed in the meeting of members. Right. However, a private company may remove the directors by other means if the constitution allows. Now, there are two ways in looking into a procedures. If the company has constitution, right? So look at the procedures mentioned in the constitution of the company. Follow the procedures, right? Unless there is nothing mentioned in the constitution, then the company will refer to Companies Act. And also, if the company decided not to have a constitution from the very beginning, from it was being incorporated, they have no constitution at all, so the company need to follow procedures in the Companies Act. Okay. So for example, if they have constitution, the constitution provided that director may be removed by the board of directors. That is sufficient. Okay. So they just follow these procedures. Okay. So we go to the next slide. Disqualification of directors. Okay. What does it mean by disqualification of directors? All right. When a director actually he has been appointed, okay, he has been appointed, he's been doing his job as a director, and suddenly something happens, some situation happen, okay, he being disqualified from his position. So automatic disqualification provided by section 198 of the Companies Act. Okay, what are the automatic disqualification? Bankrupt, when the director being declared bankrupt by the court. Okay. Second, if the director being convicted for offense relating to the management of company. What does it mean, relating to the management of the company? Which means that mismanagement of the company. We have to refer to section 213, section 217, and section 218. Right? When the directors breached his duties. Okay. Or section 539 of the Companies Act that provided if a director failed to keep proper account of the company, he is deemed to committed an offense under the Companies Act. Alright. Number 3, when the directors being convicted for bribery, fraud, or dishonesty. Under what law is this? Okay, bribery. Okay, this is fall under the criminal law. Okay, bribery. Right. Next, resignation of directors. Resignation of directors. How can a director resign from his post? All right. Director could resign from his post by giving proper notice to the company, all right, in pursuant to section 208 subsection 3. Okay. However, even though by giving proper notice, the director must see the circumstances of the company, the situation in the company. How many directors left if he resigned, right? Because a director, if one director left, the company still have sufficient number of directors, it should be fine. If this director left and then the company, has not achieved the minimum number of directors, so the current director could not resign, right? The director could only resign if the company has minimum number of directors. If the resignation would result in the public company having less than 2 directors, he is not allowed to resign. This is resignation of directors. Okay. Have sometimes read this. Okay, read this. We'll see whether you do understand or you do not understand the jokes. We need jokes lah sometimes. Don't be so stressed, When you learn, you're being so stressed, forcing yourself. Just cool, right? Calm down and try to understand what I'm trying to say. Of course, numbers are words, and words, two different areas. Accounting and law, mashallah, very different. Thank you very much. So we meet again in the next lecture. Bye. Assalamualaikum warahmatullahi taala wabarakatuh.